Monday, you have entered a new area of law, the concept about property, particularly real property. I think many of you, I suppose some of you may have already learned some of this concept, but many of you may not have understand or may not have understood this kind of legal analysis of ownership of property. So I'll give you an example here to follow up that concept of trust, how this concept of trust is being applied to ownership of property. Okay, X and Y, two persons, X and Y, come to live together. X, the man, purchases a flat, but registers the ownership of the flat in the sole name of Y, the woman. Okay? If this is not a gift to Y, then under our legal analysis, X is the registered owner, or we can call her the legal owner. Registered owner because the flat is registered in her name. Legal owner because she is holding the legal estate of that property. X, who pays all the purchase price and or the mortgage installment, is the de facto. De facto means the genuine or equitable owners. He holds the equitable or beneficial interest of the flat. Okay, so we have this two legal tradition, common law, equity, comes together in the analysis of ownership of a property. Now, if X uses his own name to purchase the flat, that is to say, register the flat under his own name, then we will have X simultaneously the legal and equitable owner of the flat. Because if you register as the owner, you are the legal owner, you hold the legal estate of the property. You pay the purchase price for the flat, or if you mortgage to the bank and pay the mortgage installment, then you hold the equitable interest of the flat, and you are the equitable owner of the flat. And this is, the most normal or common situation. People will purchase real property and register property in his own name. But under our legal analysis, if that's the case, then that person is both the legal owner as well as beneficial owner of the property. Now, as I said, we have to use that concept of trust to understand this structure of legal and equitable ownership. As legal owner, X is holding the land on trust for the benefit of the equitable owner, who is X himself in this example. In the earlier example, if X does not intend to purchase the flat as a gift to Y, then Y, being the legal owner, is holding the flat on trust or for the benefit, holding on trust for the benefit of X. Now, I give the word resulting. Now, if you have studied obligation with me, you should learn this concept, resulting trust. There is a legal presumption. Legal presumption means that the court will treat that is the reality, unless you have evidence to rebut that presumption. And the presumption is that if you purchase something, then you will be treated as the real owner, even if the property or that thing is registered in another person's name. So, Y, being the legal owner, but she pays nothing or make no contribution to the purchase price. And X is the only person who contributes to the purchase price. Then he will be the only equitable owner. And this kind of presumption will apply whenever we have someone purchase something in the name of another person. The presumption is that the person is the equitable owner, and the person who is registered as the owner is only the trustee holding the property for the benefit of the person who contribute to the purchase price. That is the meaning of resulting trust. Now, and this is partly because of the separation of the legal and equitable ownership that the concept of landlord makes difficult and conveyancing make complicated in Hong Kong. And it is not just a theoretical problem. There is genuine and serious consequence if you do not really distinguish the difference between legal and beneficial ownership. Because the worst scenario would be if you purchase a real property from a registered owner, you may end up getting only the legal estate, but not at the same time the equitable interest of that property. In that case, you are holding the property on paper only. You have no right to the benefit of that property. Because under trust law, the beneficial owners, there may be more than one beneficial owner, the beneficial owners who own 100% of the equitable interest can request the legal owner to convey the legal estate to them. If the legal owner refuses, then these beneficial owners can go to court and ask the court to compel that legal owner to convey the legal estate to them. Therefore, even if you are registered as the owner of a property, if you do not hold any equitable interest in that property, you are only an owner on paper only. As equitable interest is in Persian name, we say equity is in Persian name. Real property is, or legal ownership is in rem. When there is some dealing in land, such as transfer the land, mortgage the land, can an equitable interest be enforceable against a third party? Now, this is the case when you look for a flat, for example. You hire some estate agents to look for that flat for you. And the estate agents may introduce you to view or inspect different facts. And how can they know? How can the estate agents know the person they deal with are the owners? They can only check the land registry and see whether the person are the registered owner. There is no way one can really ascertain who is the equitable owners. Now, in that case, if we have an example in which the legal ownership and equitable ownership are split two, that is to say, there is a legal owner, there's an other person who is the beneficial owner. Now, when someone who wants to deal with this property, he can only deal with the property with the legal owner, because the identity of the legal owners can always be ascertained. But how can he know this person is the equitable owner at the same time, or he is really the trustee holding legal ownership? So, say for example, if some trustee is not really trustworthy, he or she try to sell the property without the consent of the beneficial owner, then how can the beneficial owner protect his or her interest? Now, at common law, of course, it means also inequity, because common law and equity are now combined. The priority of legal rights and the equitable interest of land are governed by this doctrine of notice. And you should learn one maxim called equity's darling. Equity's darling. This equity's darling states something like this: equitable interest prevail over anything except a bona fide purchaser for value and without notice. And this notice is the concept of the doctrine of notice. What does it mean? Now, in short, a third-party purchaser, if you want to purchase a property, of course, you can only deal with this transaction with the legal owner. So this third-party purchaser is not bound by any equitable interest in the land, because there's no way for him to find out if, but there is condition for this to apply. The condition is he is a bona fide means real, genuine purchaser. It's not, conspiring with the legal owner to cheat the beneficial owner. If that's the case, of course, equity would not help him. But if he's a real owner, really looking for a flat, and being introduced to the legal owner by estate agents, and he paid the purchase price, of course, the purchase price must be a reasonable price. It could not be $10 for a 10 million flat. Then it is obviously not a bona fide purchaser. For reasonable value of the land, pay the price, that means, and without the notices of the existing equitable interest, not representing by the legal estate. That is to say, if this bona fide purchaser knows that the person he is dealing with is only a trustee, then no matter whether he has paid the fair market price of the land, he would be bound by the equitable interest existing in that property. However, if he has no knowledge of the existence of an equitable owner, existence of equitable interest not represented by the legal estate. Legal estate refers to the legal ownership, because in most cases the person who holds the legal estate is the same person holding the equitable interest. So if he is not aware the existence of any equitable interest not represented by the trustee, then he can get the property free from the interference of the equitable interest. This is called equity's darling. Now, again, it may be a little bit abstract. Put this concept into the example we've just outlined, X and Y situation. Now, Y is the woman who holds the property under her sole name. Y sells the flat to Z. a third party. If Z pays a reasonable price, that is for value, and Z does not notice the equitable interest of X, who is the one who paid the price of the flat, X can take the title of the flat free from the equitable interest of X. Okay? Conversely, if either Y transfer the flat to X as a gift or underprice, I just give an example as don't go to the extreme as a gift, then Z would not be the bona fide purchaser, or it is significantly the selling price is significantly lower than the market price. That would also make Z and not a bona fide purchaser. Or no matter how much Z has paid, Z has the notice of the existence of X interest. Then, if that's the case, even if Z becomes the registered or legal owner of the flat after the transfer or sale, Z still holds the legal estate of the flat on trust for the equitable interest of X. So two conditions to get rid of the equitable interest. One is bona fide purchaser. You pay the fair market price for the property. Number two, you have no knowledge about the existence of any equitable owners in that property. If you can satisfy these two conditions, then you can get the property free of the equitable interest existing before. Because equity is in Persian now. If there's any loss suffered by the equitable owners, he can sue the Persian, not the land. Sue the Persian, that is Y. And if Y has money, then they have to pay back to X. But the interest would not be attached to the land, which would then, if there's the equitable interest is attached to the land, then it would affect the ownership of Z. Now, so doctrine of notice is the most important one, because even Z pay a fair market price or even higher than market price, if he has notice of the existence of X, then equity standing would not help him. So that is the doctrine of notice. There are three kinds of notices that will befit a third party purchaser. Actual notice. Now that is, he actually knows, oh, X is the one who paid the purchase price. Constructive notice. Now, this one is very straightforward. No need to explain. The other two, constructive notice and imputed notice, is a little bit more complicated. Now, constructive. Why is constructive? Because it is a notice constructed by the court. That is to say, the person may have no actual notice, but the court will treat that person having the actual notice. And this is the knowledge when a purchaser would have, if proper inquiries have been made or ought reasonably to have been made. In other words, the circumstances is so suspicious that a reasonable person would think, well, wait a minute. Are you sure you are the equitable owner of this property, even though your name is being registered as the owner? That was this kind of situation, or there's evidence to suggest that this registered owner is not the genuine equitable owner. Things like if you go to inspect a property and the owner tells you, well, I don't have income I have not worked for 2 decades already. Well, then it will give you some reason to ask. Well, in that case, is this property belonging to you? Because the property was just purchased 2 years ago. Where is your income? You would ask that kind of question. If this kind of circumstances would give rise to constructive notice if you do not ask, if you do not make inquiry. Imputed notice is even a little bit further away, one step away from constructive notice. This is the actual or constructive notice of an agent acting for the purchaser. Now, here come with this landmark case in Hong Kong, Wong Chim Ying and Chen Kum Wing, known as bus driver Wong's case. Because this Mr. Wong was a bus driver at the time the case was heard in court. What happened in this case is that Mrs. Chen was looking for a flat. She was introduced to a flat by an estate agent. And she has no time herself to inspect the property, so she sent her daughter to examine the property. And the daughter came back and gave positive comments on the property. Well, nice flat, good view, with car park, etc. And then, 91, you should remember, 1989 was a critical year. I'm not talking about political issue, but talking about real property market. After June someday in 1989, the market price dropped in Hong Kong drastically, right? And at that time there was also, just like today, many people try to immigrate, and there's something, the story is something like, the daughter told the mother, well, the owner was a lady, Madam Zhang. She said she is going to immigrate to Canada, so she was willing to, sell the property to us at a lower than market price. So, mother, okay, good. Well, in that case, I signed the preliminary sale and purchase agreement. And after the preliminary sale and purchase agreement is signed, then they would instruct solicitor to represent them to complete this sale and purchase. Solicitor representing Mrs. Xiang checked the land registry. Okay, the property was registered in the sole name of one Madam Zhang. And that Madam Zhang was the person who opened the door to the daughter of Mrs. Zhang. And of course, the daughter also told her mother, well, I saw the marriage photo of Madam Zhang and with a guy, and he said, well, they are a couple living together, something like that. After Mrs. Zhang Chen paid the purchase price, several $1 million, and got the assignment of that property, that is the deed to transfer the legal ownership of the property from the previous owner, the vendor, to the purchaser. She also got the key to go to the flat. But when she opened the door, the flat was not vacant. And it was still occupied by Mr. Wong. Mr. Wong was the husband of Madam Zhang, and he said that he has no knowledge that Madam Zheng has sold the flat, and he claimed that he was the equitable owner of the property because all the purchase price was made by him. And during the trial, he was able to produce all the bank record to see, to prove that money paying the mortgage price of mortgage installment of the property all come from Mr. Wong. Okay, so the equitable owner and this purchaser went to court and let the court to decide who should get this property. And the problem with Madam Zheng is that she had the imputed notice of the existence of the interest of Mr. Wong. Imputed because her agent, the daughter, has inspected the house, learned of the existence of Mr. Wong, and also learned that Madam Zheng has no job, etc. So under that circumstances, in order to take advantage of the equity darling, Madam Zheng should have made inquiry. Well, you're married. Did your husband has any equitable interest in this property? Or even better is to get him to have an interview to see whether he was aware of the sale and whether he has any interest in the property. So she was defeated by this imputed notice, and the flat went back to Mr. Wong to pay several $1 million and get nothing. So I'm not trying to scare you, but that is the law. Bona fide purchaser with value and without notice. She is a bona fide purchaser for sure, but she had that imputed notice. Now, so for a while after this case was decided, there was certain practice by solicitor. Now, if you hire a solicitor to represent you as a purchaser of sale and purchase of real property, the solicitor would suggest you to make a visit to the flat if it is still occupied by midnight. Make sure everybody was in the house, counting the slippers or shoes, see whether everybody was there, and ask each of the person present in that flat to sign a statement that they agree the sale. Now, in that case, the purchaser would be protected. But of course, the better way is to purchase a vacant premises. In that case, you would not have no evidence to give rise to the constructive notice or imputed notice. But anyway, that is the reality. You may, if you are not careful enough, you may end up purchasing an empty title because ownership of land is understood or operated by law in this way. We have the split of legal ownership as well as equitable ownership. And it is the equitable owners who has the real interest in that property. And you must, when you purchase a property, you must acquire not just the legal ownership, you must have the equitable ownership. Otherwise, you got nothing. Now, in fact, in many parts of the world, for example, in England and Wales, they have developed certain system of registration of title to avoid that kind of situation, as demonstrated in Wong Chim Ying and Chen Kum Wing's case. And under this system, one merely refers to the register. There is a central register of all titles of property to see the vendor has the title to the property. Of course, that would include both legal and equitable title. Now, Hong Kong does not have that kind of registration. We have our own system of registration of title under the Land Registration Ordinance, Cap 128. Now, this particular registration title only register transactions affecting the land. Transactions include sale and purchase, mortgage, or granting lease by the owner. But that registration system does not prove that the vendor has good title to sell, or that vendor, that registered owner, is at the same time the holder of the equitable interest of the property. So, we have one more difficult task to overcome in Hong Kong. We have to be sure that no equitable interest would be attached to the land, so that such equitable interest would befit our purchase of the property. But even though the registration ordinance, the system under the registration ordinance does not guarantee good title or does not give full information of the legal ownership, of the ownership of the property, it is still necessary to conduct what we call a land search in respect of the property registered under Land Registration Ordinance, in order to learn whether this registered owner, the vendor, is holding a good title or bad title. And there is one more important thing in relation to this registration system. The estate, legal estate, or interest, equitable interest registered in that system has priority over other estate and interest created after the registered interest. We'll come back to this in details later about how this operates. But at this stage, you should at least understand how this land registration ordinance will help purchaser to know whether they are going to be bound by some equitable interest. Now, this ordinance, in a way, has made the doctrine of notice not applicable in most of the cases. Of course, there is an exception, and that exception exactly fails comes up in Wong Chim Ying's case. Otherwise, Mrs. Chen would not have purchased some empty title. Now, under Section 3, subsection 2, and Section 4 of this ordinance, it is expressly provided that, now, if you have an legal estate or equitable interest, which is registrable, that is capable of being registered. What are the legal estate and equitable interest that is registrable? If the interest or estate is created in writing, then they are registrable. Once you have a registrable estate or interest, then you must register under the Land Registration Ordinance. Otherwise, your interest would have no effect whatsoever before a bona fide purchaser for valuable consideration. So, equity styling requires two conditions: notice and value. Land Registration Ordinance, in effect, take away the requirement of notice, because you have to make known yourself, you have to make your interest known to the world yourself by register the interest under the Land Registration Ordinance. And Section 4 goes one step further. Even if a bona fide purchaser is aware of the existence of an equitable interest, if that equitable interest is not registered but registrable, the bona fide purchasers can still take free. So that requirement of notice gone under this Land Registration Ordinance. I think you will immediately ask me this question: then why Mrs. Zhang would still get an empty title? Going back to the concept we just learned, or some of you have learned that already, resulting trust. What is resulting trust? That is the presumption that if you make purchase price for the property, but register it in another name, the equitable interest going back to you, result going back to you. And that is a legal presumption. It is not created in writing. It is created by legal principle. So resulting trust is not registrable. When the equitable interest is not registrable, then Land Registration Ordinance does not apply. And we have to go back to equity styling. And therefore, in that particular case, notice is still required in order for Mrs. Zhang to defeat the equitable interest of Mr. Wong. Okay? So there are all these legal principles going against one another, and therefore it is important for you to hire a capable lawyer to advise you when you purchase real property. Now, of course, under normal circumstances, it is not necessary, because everyone is honest, everyone is doing the right thing. There should not be any problem. And the capable lawyers hire is just in case someone is cheating, and this capable lawyer could detect the problem before completion. And he or she will advise you, okay, stop completing this sale and purchase, because you are going to have problem. Now, in fact, again, another question you will ask, why Hong Kong would not adopt the same system as in England? In fact, we have tried. In 1996, before the Hong Kong became Hong Kong SAR, there was a bill prepared and pending to be passed by the Legislative Council. But the bill was not dealt with because there's too many ordinance have to pass before 1st of July. And after 1997, everybody just leave it aside until it was picked up again in 2004. The bill was duly passed by the then Legislative Council. You say, well, in that case, why? Tommy Ho, you're wasting my time. You know, you're talking about something which should have been superseded by law. Wait a minute. Section 1.2 said, the ordinance shall come into operation on the date to be appointed by the Secretary for Development by notice published in the Gazette. So when it was passed, this ordinance has not come into effect. And unfortunately, the Secretary for Development, Mr. Chan, he was the previous Secretary for Development, and now it's Mr. Wong. None of the Secretary for Development, including our current CE, when she was the Secretary for Development, they have never published such notice. Therefore, the Land Title Ordinance has not come into effect, and we are still stuck with the Land Registration Ordinance. Well, maybe they want to give more chance for people like me to earn more money. But that is the reality. If this ordinance comes into effect, then much of the problem that we encounter in the conveyancing process could be eliminated. Okay, so in this introductory lecture, we talk about other things. Give you a general idea first. Okay, there are two main types of disputes in land in Hong Kong. Rights to possession. Remember, proprietary rights to possession is the most important concept for ownership of land. And therefore, the main dispute is also about who has the rights to possession to a piece of land. And the second dispute is title to land, the title to the land. Now that is the phase to call it. We do not say title of the land, but title to the land. Also possession to land, to the land. Title, of course, refer to actually legal ownership again. You know, what kind of title you have. You may have proprietary right as owner, you may have proprietary right as tenant, you may have some rights of physical possession by virtue of a contract, etc. And the essence of ownership is the proprietary rights to possession of land. Of course, here we are using different phase. For leasehold land, the tenant has the right of exclusive possession of the land for the duration of the lease. Exclusive possession, that means he's the only one who can have or who has the highest right against the whole world. And during the lease, the landlord only has the reversion right, remember that, to the land. And that is to say, the landlord has the right to repossess the land at the expiry of the lease. So the land would reverse back to him. And the tenant, who has the exclusive possession of land, may not be in physical possession. Okay, so this concept of possession is a little bit tricky. We are not just talking about physical. But if someone, for example, including the landlord, enters the land without the tenant's permission, even if he's the landlord, during the duration of the lease, the landlord could not enter the land without the tenant's permission. Therefore, that is why we say it is an exclusive possession. The tenant may eject them by enforcing his right of exclusive possession in a legal action. And a person who enter land not belonging to himself or herself and without permission enters the land as a trespasser. Now this is an important term to learn in land law. Trespasser is anyone who enters another person's land without permission. Now, tricky thing about this perpetual right of possession is this. By means of the physical possession, physical means you actually stay there, occupy the land. He has a right over anyone who is not in physical possession of the land. So, say for example, there's a piece of land in the new territories. No one knows who owns this land. Now, if you have a chance to slip in and then lock up that piece of land by a gate, by a wall, then you would have a right over any other trespasser who is not inside the land. So if another trespasser came to this piece of land, oh, this is a good piece of land, I want to occupy it. Now, even in the absence of the landlord or tenant or whoever, because you are already in physical possession, you have a right over this trespasser. You can eject the later trespasser. Of course, this trespasser, the first trespasser, who has only physical possession of the land, cannot defeat the tenant or the landlord because they have higher level of perpetual rights to the land. Once, say for example, this guy has stayed on that land for 3 years, wow, that's a long period of time. But even that, once the landlord or tenant comes back, they can bring an action in court to eject this trespasser. And the trespasser has no defense. He has to go invariably. Now, but we have a further difficult concept called adverse possession. If the trespasser took physical possession of the land, at the same time he had what we call technically animus possidendi. May not be very correct word. This is a Latin phrase. Yeah, SSI. I find it strange. Possidendi. Yeah, okay. P-O-S-S-I-D. Yeah. Without the N, it's Dendi. Okay. This is intention. Animus means intention. Intention to possess. You have physical possession as well as animus possidendi, and you occupy the land for 12 years. Then you would acquire what we call a negative title to that piece of land over and above anyone in the world. Of course, we are talking about pirates' land. If it is government land, it would require 60 years. And before the 1st of July 1991, it was 20 years, but now the law has shortened the period to acquire adverse title. Now, by virtue of your adverse possession, meaning physical possession as well as this animus possidendi, the real tenant or landlord has no rights to bring in an action to eject the trespasser. And in fact, if you are patient in love And if the government was lazy enough, you may be able to adversely possess government land as well. And in fact, about 2 or 3 years ago, someone in South Kiwan actually successfully adversely possessed a government land. Now, the trespasser would have a title over and above all, and will have a negative title, because this is not something he acquired by paying money or doing some positive thing. So we call it a negative title. He will have a negative title, even the real landlord cannot defeat. Now, so the first major type of land dispute is whether a trespasser, sometimes it's also known as a squatter, has successfully adversely possessed a particular land in question. In fact, in the last 10 years or so, there are many, many such cases litigated in court, in high court and district courts. And I have dealt with a few myself. The second type of dispute in title, mostly happen at the transfer of land, and usually during a sale and purchase. In fact, this is the part we will concentrate on in our syllabus. Adverse possession is not so important for our syllabus. Our syllabus is about sale and purchase. And the conveyancing system now in Hong Kong requires a vendor to prove that he or she has a good title to the land that he or she is selling. And when the vendor said, "Oh, I have good title," of course the purchaser has the right to ask question. And the technical term is, we do not say ask question. We will say to raise requisitions on the problem or defect of the vendor's title. Once the purchaser raises requisition, the vendor is duty bound to give satisfactory answers. Now, dispute comes when the vendor said, "I have fully answered your requisition," but the purchaser said, "No, you have not clarified my requisition." Now, in that case, they will have dispute, and they may end up to have a vendor-purchaser summon in the court for the court to determine whether certain requisition has been answered satisfactorily. For some time, one party may choose to say, "Oh, the other party has repudiated the sale. They have terminated the sale and purchase agreement wrongfully. Therefore, they sue for damages or specific performance." And also in that scenario, the court will have the opportunity to determine the title to be sold by the vendor to the purchaser. So this is the second main dispute of land in Hong Kong. Now, going to briefly introduce other legal concepts that we have to study in our syllabus. Mortgage. Mortgage is a form of interest in land. Now, in the past, the law on mortgage is very complicated. At least when I studied LLB myself, the law on mortgage was complicated, deriving from the English common law. Now, but basically, mortgage is a way to secure a loan. You want to borrow money from the bank. The bank is afraid that you are not able to repay. Then they want some kind of security. One form of security is to ask someone to be your guarantor. This guy will guarantee if you fail to repay, he will pay for you. But it is difficult to find someone who is so foolish to guarantee your loan. So if you have some real property as security, the bank will still advance you the loan. If you fail to pay the loan, you can get the property, either sell it to get the money back, or occupy the property for other purposes. So mortgage is really the interest in land possessed by the creditor, the bank or finance company. Because of this particular legal right created, he would have interest in your land. Once you fail to repay, he can get the land from you. But in Hong Kong, after the 1st of November 1984, technically mortgage no longer exists, because later on you'll know in the Conveyance and Property Ordinance there is a particular section saying that all mortgages would be converted into what we call a legal charge. Basically, the difference is this: in the old days, when we have mortgage, now you have the borrower B and the creditor C. Now, there was first of all a loan agreement between them, okay? And there is a second agreement called mortgage agreement. Something like, if you fail to repay your loan, then I am entitled, creditor, I will be entitled to get your property. Now, in executing this mortgage agreement, the borrower is required to transfer the legal estate to the creditor, and him keeping the equitable interest. But since the legal estate is vested on the bank, he cannot deal with the land without the permission of the bank. In that case, the bank is secure. Now, the legal charge created to replace mortgage in Hong Kong will allow this guy to keep both the legal estate as well as equitable interest. But at the same time, he's make this no longer mortgage agreement, but an agreement. Well, you can still call it mortgage in our daily language, to execute a charge, or we call it legal charge, on the property. And this will be registered in the Land Registration Ordinance, saying that the property is now charged to the creditor. Now, with this legal charge, the creditor, the bank, can still get your property in one way or either get the property for sale or get the equitable interest as well as legal estate of the property when you fail to repay the loan. But the good thing is that this guy can keep both the legal estate and equitable interest, and he can, in theory, if the property is very valuable, he can execute another legal charge to another creditor to raise more money. It will give more freedom to the borrower. Now, but learn some technical term first. The one who gives the mortgage is the borrower. He is called a mortgagor. O-R. Mortgagor. Okay? And the bank, the creditor, is called the mortgagee. G-E-E. Okay? When it's become a charge, mortgagor become chargor. O-R. And mortgagee become chargee. So the land originally belongs to the mortgagor and chargor. But if the mortgagor failed or chargor failed to repay the mortgage loan, then the mortgagee or chargee may have the right to get the land. Section 44(1) of CPO actually said that mortgage can only be effected by legal charge, and the legal charge involves a deed. Because a deed is a document signed, sealed, and delivered. It is registrable, and it has to be registered in the land registry. So everybody in the world will know the property is under a legal charge. And in that section 44, it is also expressly provided that the rights and protection of a chargee will be the same as a mortgagee before this date. And we'll study about mortgage or charge in more detail in later chapters. But one thing that I want to touch on at this stage is a concept called equitable mortgage. Now, there are many ways that an equitable mortgage can be created. But one very easy way to create an equitable mortgage would be the owner of a property deposit the title documents, the title deeds of that property to the creditor. Now, without any writing, any written agreement. Now, you give me the money, I'll give you the title document. Now, without the title document, of course, you cannot sell the property to third party. But this equitable mortgage, because it was created in this way, not in writing, it is not registrable. And therefore, it also becomes a pitfall. It could be a potential risk created to bona fide purchaser. And later on, you'll know that if you want to create a legal interest or legal estate, you must use a deed. Now, if you do not use a deed, just execute a written agreement to create a charge, then that charge cannot be a legal charge. It could only be an equitable charge. So, again, you can see why the land law is difficult. Lastly, this is the concept for license. License is not the license for running a, say, restaurant, etc. But for land law, license is a permission to enter or occupy some land. But license does not create any proprietary rights in the land. And license is only and always a personal right, but not a proprietary right. However, if you are a licensee is the one who gets the license. The licensee who has the right to possess certain land under a license may eject any trespasser who enters the said land without permission of the owner, tenant, or the licensee. Say, for example, if your father and mother owned a flat, of course, this is not the right way to say it, but just use this common language. Your father and mother own a flat. You stay in the flat. Then you are only a licensee. You have no legal right whatsoever in relation to that flat. And if someone who has no permission of your father and mother and no permission of you try to enter your flat, you can eject him by virtue of the fact that you are a licensee to occupy that flat. Okay, so there are so many different concepts covered in this first lecture. I think you need time to we read them and digest them. But they are very important for the study of this particular module, land law and conveyancing. If we do not know them, do not understand them, then it would be difficult for you to follow what is going to come in the remaining lectures. Now, the second lecture. Now, relax, because this chapter is created to make things easy, even though we are dealing with the most complicated land concept in Hong Kong. Now, A owns a piece of agricultural land in Tai Po. He wants to sell the land to B. B says that A only occupies the land under a lease, but is not the owner of the land, and therefore the land is not worth the price A is asking for. Ask you to advise A. Does A own a piece of land, or A being a tenant? And I think by now you should know A can only be a tenant, because all land held by the Queen of England before the 1st of July 1997, and after this day is now held by the government of Hong Kong, SAR, on behalf of the state of PRC. So at no time since Hong Kong became a colony of England that any individual in Hong Kong can be the owner of a piece of land. Now, the English Church, here, of course, is the owner of the piece of land on which St. John Cathedral stands, because that is the only freehold land in Hong Kong. So, in Hong Kong, all so-called owners of land actually are tenants instead of landlord. The landlord, before 1997, 1st of July, the landlord was Queen of England, and now the state of PRC. Now, holder of land, that is to say you hold, I don't know how to explain that meaning of holder, but you hold right, legal right in respect of a piece of land. And this legal rights are measured by different duration of time. Remember, this is one of the meaning of estate, duration of holding of land. And two main types of estate: freehold estate, indefinite period; leasehold, fixed period. And the so-called freehold estate comes from the English feudal system, but it's no longer useful or necessary for us to know the detail about the history. But for practical purposes, a convenient way to distinguish this freehold and leasehold is that leasehold is always for a fixed term. So we have a legal jargon to describe the leasehold interest, a term of years absolute. A terms of years absolute refer to a lease or leasehold land. For freehold land, it is indefinite duration. That means forever. I don't have to repeat the last line. Now, talking a little bit about history. You know, the date for Hong Kong to become the colony of England was January 20th of 1841. Now, if you have studied history, well, because you are young, and I don't know whether you need to study history. When I was a secondary school student, we need to study history. we learned that Hong Kong was ceded to England by the so-called Beijing or Nanjing Convention, but in fact, it was a convention called Convention of Chunbi. The Chinese is called Chunbei Chouyuan, signed on this day. But later on, this convention was given up and superseded by the Convention of Nanking, dated August 29, 1842. More than 1.5 years later. But actually, the British Army already occupied Hong Kong in January 1841. Now, under this Convention of Beijing, signed in 1860, so in the very first place, only Hong Kong Island was ceded to Great Britain. And then we have another convention called Convention of Peking, signed about a decade later. South of the boundary street in Kowloon was ceded to Great Britain. Now, for those who are all in love, you should have remembered that why we are calling that particular area Kowloon City, Kowloon City, because in the old days there was actually a war, a war there, not just a war, but there is really you can call it a city. That was an area in which, in the early days, the Qing government would have a troop of soldiers stay there, because that was the boundary between the Qing land and the colony of Hong Kong. So south of boundary street was also ceded to Great Britain. Now, 30 or 40 years later, there is another convention, second convention of Peking, and the area now known as the New Territories. Now, what are the lands of New Territories? Land north of boundary street to the Shenzhen River, south of Shenzhen River, and altogether 235 islands. All this land was leased to Britain for 99 years. You can count. 1898, 99 years, 1997. Therefore, we have this problem of 1997. All comes from all these conventions. Okay, as I said, even though the Nanking Convention was signed in 1842, the first one, Chunbei Convention, was signed in 1841, and in fact, 1841, British Navy landed on Hong Kong Island and made Hong Kong, the Hong Kong Island I'm talking about, the colony of England. Now, soon after they occupied the Hong Kong Island, they started to sell land, because Queen was the owner. They can sell the land to people living on Hong Kong Island. Now, in those days, because Hong Kong was still primitive, whereas Macau has been occupied by the Europeans for several hundreds of years. So the government of Hong Kong actually have offices in Macau. And the land auction in May 1841 also took place in Macau. But when the first land auction took place, it was not clear whether the land to be sold should be on freehold or leasehold. And only a few years later, 1843, the government of Hong Kong finally decided that the land sold since the first day, the first land auction, should be on leasehold. Because of this decision, no one in Hong Kong could claim himself or herself a landlord. Now, Remember, on Monday, one of you asked me, how about Thai Cuisine? They have 999 years list. In fact, in the early days, the government was really giving randomly, and full gut reaction. So when they auctioned the land, they put up different terms: 999, 9975, or even 21 years. And since 1898, when New Territory becomes part of Hong Kong, the norm has become each list granted by the government would last for 75 years. But people begin to complain, well, for 75 years are too short. Therefore, the government in those days grant further what we call option to renew the list for another 75 years. That is to say, upon the expiry of the list, you may apply to the government to renew the list for another 75 years. And that happened before 1997 in many cases. But when the list was renewed, the lessee, the one who get the lease, have to pay a premium, pay a huge amount of money to the government to renew the lease. Now, for New Territories, because the land itself was leased from the Qing government for 99 years, you could not grant any freehold. So all land in the New Territories are leasehold. And now you only got 99 years. The government was very cautious in those days. They could only grant lists up to 75 years. And because actually you have 99 years, so they come up with a ingenious idea. They give them a right to renew for 24 years. Then it would come 99. But just in case, the land has to be returned to Qing government. At those days when it was thought the Qing government would not be overthrown, the renewal of the lease is 24 years less 3 days. That is to say, 28th of June 1997, so that the government can collect all the land back from the lessee and give it back to Qing government. That was the design when this list in the New Territories were being granted. Just in case something happened, they have 3 days to do something to fix it, any problem to be fixed. And the problem is, New Territories, when it was granted to the British government, the New Territories, unlike Hong Kong Islands, are connected with the mainland China. And in fact, there are many people, Chinese people, already occupying the New Territories, unlike the Hong Kong Island. And land in the New Territories has been held under the Chinese, what we call the customary tenure situation. And in fact, in China, in those days, in the Qing government, the land are all freehold, even though the owner can lease it to tenant. And the Chinese office, who was responsible for the land titles in the New Territories, of course, New Territories is the Hong Kong way of description, in those days was the Canton Magistracy, Guangzhou Fu. And, it was New Territory was so far away from Beijing. The capital. People, including the officials who were assigned to rule new territories, always thought that they could do things as they liked, and they did not have to follow strictly the Qing law. So many irregular transactions has been going on for centuries before the British rule, and that create many title problems in the new territories. Now, the British people are so familiar with the rule of law, they could not tolerate that kind of things. So they decide, the government, actually, Hong Kong government, decide to assume the land in the new territories to cure such problem. So no matter who were the owners of the new territories land, their title were being taken back or taken away by the British government. So they enact an ordinance called New Territories Ordinance 1910, and provides in Section 8 that all land in the new territories is hereby declared to be and to have been from this day, July 23rd, 1900, the property of the government. So they get all the land, collect all the land back to the Hong Kong government. Now, at that time, people was panic, well, I used to be the owner, but now the Hong Kong government get my land back. What does it mean? But in fact, they don't have to worry, because when the Convention of Beijing was signed, there is an agreement between the Qing government and the British government. There will be no expropriation. You cannot just take away people's personal property. And that if land is required for public purposes, it shall be bought by a fair price. So when new territory was listed to the British government, they have already agreed. They, meaning the Qing government and the British government, already agreed. The British government would not expropriate property belonging to the residents in the new territories. So what does it mean when they say the property in new territories become the property of the government? The whole purpose in those days was to get back the title of the land and re-grant the title to the original owners. Now, this concept is important because that was echoed in Article 105 of the Basic Law. When Hong Kong ceded to Britain, the Qing government wants to take care of the interests of the Chinese resident living in new territories. Likewise, when Hong Kong is returning to China, the British government wants to ensure that the residents in Hong Kong would not be deprived of their private property. Therefore, they make this particular agreement in a joint declaration, and it becomes Article 105 of the Basic Law. The Hong Kong Special Administrative Region shall, in accordance with law, protect the right of individual and legal person to the acquisition, use, disposal, and inheritance of property, and their rights to compensation for lawful deprivation of their property. Now, if the government needs your land for public purposes, that the term we use is resumption. Now, that is lawful deprivation of the property. You have to pay a price. So such compensation shall correspond to the real value of the property concerned at the time when it was being deprived, and shall be freely convertible and pay without undue delay. You cannot just say an empty promise. Now I get your land, I resume your land, I'll pay you 100 years later. No, you cannot do that, according to Article 105 of Basic Law. So the same spirit of protection of personal property, was going through from 1898 to 1997 or 1991 when Basic Law was drafted. Now, therefore, when the government said, all the property belonged to the government, the purpose was not to confiscate the land in new territories, but to regulate the title by assuming the property first and grant the title back to the original landowners. And because the Hong Kong government only had 99 years under the list, so they could only give the lessee a lesser title, therefore only 99 years minus 3 days. And they could never grant freehold land on new territories. And among the many problems, I'm sorry, I forgot we should have a break. So why don't we take a 15 minutes break now?